Okay, thank you. Just a few cases to review this month. As you well know, the whole COVID situation is generating a lot of religious liberty issues and a lot of religious liberty, tricky religious liberty questions. Recently, in fact, just a couple days ago, there was a suit filed in Maine in federal district court on behalf of over 2,000 healthcare workers, and they're challenging the governor's order that all healthcare workers have to be vaccinated against COVID-19. Now, their issue is that there is no accommodation whatsoever in that order for religious objections. There are accommodations for certain medical exceptions, but nothing for any kind of a religious objection. And so they're alleging, there are about 2,000 healthcare workers, they're alleging free exercise and religious discrimination violations. Let me read you just a little teeny piece of the complaint, because I think this is interesting. The dispute in this case is not about what accommodations are available to plaintiffs, or whether accommodation of plaintiffs' sincerely held religious objections can be conditioned on compliance with certain reasonable requirements. The dispute is about whether defendants are required to even consider a request for reasonable accommodation of plaintiffs' sincerely held religious beliefs. Now, their sincerely held religious beliefs don't relate to whether they ought or ought not to get vaccinated, but rather to the generation of these vaccines and whether they have some connection with aborted fetuses. And that's the basis of their sincerely held religious belief. Continuing, just a quick quote again, plaintiffs have all informed their respective employers that they're willing to wear facial coverings, submit to reasonable testing and reporting requirements, monitor symptoms, and otherwise comply with the reasonable conditions that were good enough to permit them to do their jobs for the last 18 months. So the question here is really going to be a Smith kind of question. Is this a neutral and generally applicable regulation? Or because there are some exceptions, at least for medical issues, does that somehow constitute this as not religiously neutral and generally applicable and therefore subject to strict scrutiny? So that's one to watch. That's out of Maine. It is called Jane Doe's 1 through 6 against Mills. Another case comes out of Yeshiva University. It's the Yeshiva University Pride Alliance and against Yeshiva University. And Yeshiva is, of course, an Orthodox Jewish university in New York City. They refuse at the university to acknowledge a gay-straight alliance club, and then there was a lawsuit that was filed. The lawsuit alleged that this was discrimination in public accommodations, that school was essentially a public accommodation. Now, as you know, a lot of times these public accommodation laws are very, very broad. However, New York's law has an exemption for what they refer to as distinctly private clubs. And then it expressly states that a religious organization that is incorporated under the education law is by law deemed to be in its nature distinctly private. And so the New York trial court held in favor of Yeshiva. We'll see what happens to that up on appeal, but I think it's a good reminder that religious exemptions have existed for a long time, including in very progressive states, from public accommodation laws and other kinds of laws that typically fall within the civil rights zone. So that's an interesting one to watch. And interesting also as others consider various models for federal legislation as well. Carson against Macon. This is a case involving, it's currently in front of the US Supreme Court. Maine, another case out of Maine, subsidizes the cost of attending high school in areas of the state where there's no local public high school. But this subsidy is not available to attend a school that the state deems to be sectarian. By that, the state means a school where the curriculum includes any kind of religious instruction. So Carson and others challenged the law as a violation of their right of free exercise. The First Circuit ruled against them, and the Supreme Court has now granted review to decide whether the law violates the First Amendment by denying an otherwise available government benefit solely because it will be put to a religious use. So this is a follow-on to the Trinity Lutheran case. It's a follow-on to the Espinoza case as well. This one's going to focus a little more narrowly on religious use of funds, and we'll see what the Supreme Court does with it. It's interesting that the Supreme Court has taken a number of these cases in fairly rapid succession. So those are the 3 cases I wanted to mention, and that's our report.
Alexander, can I ask you a question on that Yeshiva University case? Do you think that would be an easy case under the Equal Access Act if it were a high school?
You know, it might be. It's a good question. They didn't raise that particular claim, and I don't recall whether the Equal Access Act applies at all to colleges, whether it applies to religious colleges. I think it applies to public schools primarily, does it not?
I think it applies to public high schools. I don't think it applies at the collegiate level, although I could be wrong about that. But I just got me thinking that framework works very, very well at the high school level, and it seems like a club like this would be easy to, but I'm just curious. I'm just trying to figure out how that would work out.
Yeah, I think you're right, as I recall. I mean, that law came out of the context of schools, public schools excluding scouting back in the early days, and it was intended to protect scouting. It was written in an equal kind of generally applicable way, and the LGBT rights related groups kind of used it in order to have these gay straight alliance clubs in public high schools. I've never seen it applied to any kind of higher education, and certainly not any kind of a private school. So,
yeah, I can't imagine it could apply to a private school. It just got me kind of thinking how it would play out in a different setting. All right,
yeah.
thanks.